do you say your first name?
Corey Hawkins.
We're on the record as the people versus Ja'Cory Hawkins, case number 2259415. Mr. Hawkins is charged with 1 count of weapons carrying concealed the day that they set for a preliminary examination. Says here on the file or evidentiary hearing. So I believe for exam. 68. Oh, what's Mr. Kirker? I just thought it was here.
Alexander Kruger on behalf of the people, P8628.
Good morning, Your Honor. Neighborhood Defender Service by Cheryl Quick, P83973 on behalf of Corey Hawkins. Mr. Hawkins is present.
Good morning, everybody. Are we ready to proceed?
Your Honor, we have one officer here. I was just speaking with the OIC and contacting the other officer, see if he's on his way.
Okay.
He hasn't responded yet.
How long has it been?
I was just out in the hallway. They just called and texted him while I was out there.
Okay, so I'll give you about 15 more minutes. I'll handle one matter, or 1 or 2 matters ready to go, and then I'll respond to it. Okay, Attorney McCoy, good morning.
Hello?
Yes, I can hear you now. Attorney
Oh,
McCoy,
did-
can you hear me?
Yes.
Okay, good morning.
Good morning.
Are you here with Ms. Faison?
Yes.
Okay, are you ready on her case?
Yes.
Okay, we're on the record as the people versus Adriana Juanita Faison, case number 23581. Ms. Faison is charged with felony weapons carrying concealed 2 controlled substance, possession, cocaine, heroin, or non-narcotic, less than 25 grams, and count 3 weapons, a firearm. Today, they set for probable cause conflict appearances.
Alexander Kruger on behalf of the people, P86282.
And good morning, Honor Robin McCoy on behalf of Adriana Faison. P63057.
Ms. Faison, please state your full name for the record, please. Unmute your device.
Adriana Juanita Faison.
Thank you. Good morning.
Good morning.
Is there something else, Attorney McCoy, other than the PCC that you want to address today?
Well, we have discovery. We were planning to do a letter to the gun board, so we were asking for an adjourned PCC to try to adjourn that out for a few weeks to see if we can work out a resolution through the gun board.
How long do you think that'll take?
Usually I think it may take like a couple weeks or so. I guess, I don't know, Mr. Prosecutor could speak to the time frame for that, like how it's going now. 'Cause I know before it was taking like maybe.
Have you ever done a gun board case before, Attorney McCoy? Attorney McCoy, can you hear me?
I mean, my experience is, I think, I don't know, maybe a couple weeks, 2 or 3 weeks.
Okay.
I mean, I've asked my client to provide me with supporting documents, so as soon as I get it, I will submit the letter.
Anything you want to put on the record?
No, Your Honor.
All right, I'll adjourn the PCT for 2 weeks. And Attorney McCoy, if you have any, response by that time, I will adjourn for another week, but also set an exam date, just to have it, because we're already setting it to mid-February. So I will set an exam date, and you should have something by then.
Okay,
So I'll adjourn it, today to February 8th, a little over 2 weeks.
okay, February 8th, Wednesday?
Yeah, does that work?
Yes, will it be 8:30 or 9 o'clock?
Let's do 9 o'clock.
Okay, 9 o'clock.
Okay, Ms. Faison, did you get that information?
I'm sorry.
February 8th, 9 o'clock on Zoom.
Yes, ma'am.
All right, you all here.
All right, thank you, Your Honor.
Thank you.
Ms. Arthur Poe. Arthur Poe. Or Powell. Devontae Watkins.
As you hear me?
Yes, Mr. Watkins, what are you here for today? Good morning.
Hey, how you doing? I had to sign in at 9:15.
What are you here for today?
I don't know. I think I gotta get a new attorney.
What type of case do you have, Mr. Watkins?
2 felonies. 2 felony cases.
You have the information on what courtroom you should be in?
Uh, she didn't say. She just said, "Come on here at 9:15 to get a new attorney."
What's your middle name, Mr. Watkins?
My middle name,
Yes.
Kyrie.
Okay, and you said she told you. Who told you?
Mark Grady.
You're who?
Mark Gravy.
Mr. Watkins, can you please come to the phone so that we can communicate and get moving with our docket?
I'm at the phone. I'm trying to hear y'all, so the phone to my ear.
Okay.
It's January 25th at 11:30, Judge,
For what?
for an exam.
Yes, that's the term.
Term is on the case, a month. 11.
Okay, Mr. Watkins, Have you talked to Grady Demott?
No, none today.
That's who your attorney is? Is that correct?
Well, she told me to join Zoom at 9:15 to get a new one. I guess I guess they represent somebody. I don't know. It's something happened, and she told me to join Zoom today so I can get a new attorney. So I don't know.
Okay, I'll call Ms. Demott, because this doesn't make sense. Give me your phone number, Mr. Watkins.
313
Mhm.
580 2984.
Okay, you can log off. We're gonna call Ms. Demott, and then you'll get a phone call. If you need another attorney, we'll have someone call you, okay?
All right.
Good morning, the person with the phone number ending in 0643. Please state your full name. 0643.
Kamalina, yes, Kamalina Reed.
I'm sorry, I didn't make out what you said.
I'm sorry, Kamalina Reed. I think I was trying to join Zoom for a court hearing for someone else.
You want to observe court?
No, I'll have a court date, ma'am. I'm sorry.
So you want to observe court?
Yes, ma'am. I'm sorry. Yes, ma'am. I do.
Okay, you have to go on our website, 36districtcourt.org. You just Google 36 District Court, and you can watch live from our website for courtroom 438.
Oh, I'm so sorry. Thank you so much, ma'am. Thank you very much. Okay, bye-bye now.
Friend Michelle, good morning.
Good morning, Your Honor. This morning, I'm covering a case for Bill Noakes. The gentleman's name is Joel Lopez.
Okay.
It's a PCC.
All right. Mr. Foster,
Yes, ma'am.
good morning.
Good morning.
You have a traffic matter?
Yes, I do.
You should be in courtroom 332 with Judge Larry Williams. Let me know when you're ready to take down the proper Zoom information.
All right, hold on. Give me a minute. Yeah, yes, Judge, what is it?
360
360
332
332
0000.
And the judge's name was what again?
Yes, Larry Williams, courtroom 332.
Larry Williams.
And you're late for calling ASAP.
All right, thank you.
Well, okay, is Joe Lopez logged on? I don't see him.
He should be, it's showing that he is in the Wayne County Jail, Judge.
Mm. Oh. Attorney Michelle, can you call the courtroom for a moment?
Yes, of course. Give me one
Okay.
moment.
You just let it know. Okay. Whatever they choose. Whatever she suggests. Okay. You don't have to do that. Okay. Attorney Devine, ready?
Good morning. I apologize. I'm on too many Zooms this morning. I'm on Mr. Watkins and we have a conflict, so my office needs to withdraw.
Oh, he just called in. That's, okay. So.
I can text.
I told him we would call him because he was confusing.
Yes, I apologize.
Can you say what the conflict is?
My supervisor identified it and told me to withdraw. And my office's policy is to keep each other walled off, so I don't actually know what the specifics are.
Are you asking to send something in writing for motion to withdraw?
I'm sorry, what?
Are you all going to send something in writing for a motion to withdraw?
If the court would like that, yes.
Okay, then we'll be able to assign him someone to do.
Okay, so I should send that, I can send that over today. Do I need to zoom back in or?
No, you don't need to go back in. Just email it over and then we'll get him to return.
Okay, thank you.
You're welcome. Cameron, can you unmute your device, please? What's your first and last name? The person walking is Cameron.
Oh, I'm so sorry. My name is Kamalina Reed. I was trying to log in to see court for T. Dale Sledge.
Okay, so. Sledge. You haven't gotten to Sledge yet, but you have to log on to our website on YouTube, not in the actual courtroom. So if you go on to 36districtcourt.org, you just Google 36 District Court, you'll see a red link to watch live court, and go to courtroom 438.
Oh, I'm so sorry. Thank you very much again. Thank you very much. I'm sorry. All right, bye-bye.
Oh, did you talk to John? Yes, I got it. She said the 30th to 8. What time? 8:30. Okay. I'll give it a call anyway. I can talk to Attorney Barton. No. The gentleman with, the hand brace in the Wayne County Jail, who's arrested on the table,
Yes, ma'am.
did you have a question?
Yeah, my name Thomas Cortez Allen.
Yes. Did you have a question?
I was finna ask or whatever, did the lawyer appear or not?
No, I said, as soon as your lawyers appear, I will address you all. As soon as I have manual check in here, and I don't know who your attorneys are.
Okay.
As soon as they call in, I'll call your cases.
Okay, thank you.
You're welcome.
I don't wanna fall asleep on the screen, you know what I'm saying?
Yeah, I'm not worried about you. I'm just waiting for your attorneys to get here. Just make sure you, ready to go when they get here.
Yes, ma'am.
Okay. Okay. Okay, we're back on the record. This is the recall to Curry Hawkins, case 2259415, appearances.
Alexander Kirker on behalf of the people, P86282.
Neighborhood Defender Service by Cheryl Quick, P83973, on behalf of Corey Hawkins. Mr. Hawkins, great opinion.
Mr. Hawkins, one more time, your name.
Corey Hawkins.
And Kirk.
Your Honor, as I understand it, the officer Sean Perry is still on his way here, said he'd be here. About 15 minutes. He was here for the last exam and it was adjourned due to defense's request for more discovery.
Your Honor, we're gonna move to dismiss. Officer Perry was over 45 minutes late to the last hearing too. It was an issue because the document was behind anyway. We did have to resolve the discovery matter and we're here, we've been here since 9:20.
So the discovery matter was resolved. Okay, Ms. Quick, I am going to allow, what, you said 15 minutes from when now, or 15 minutes? Like, probably approximately 15 minutes. This is from when I walked in. I can 15 minutes, so that's probably about 15. Yeah, 15, I'll recall it. That's it. 15, 15.
Thank you, Your Honor.
Okay, thank you. we're ready on Lopez.
Just stand right here.
Okay.
Stand in the picture. Yep.
Yeah. Yeah, still here. Yeah, I still here.
Okay, Attorney Bashad, you need to speak to Mr. Lopez? Or we
That would
ready
be
on-
that would be lovely, Judge.
Yes, ma'am. Good morning.
Oh, yeah.
Back out.
Mr. Lopez was never transferred, Judge.
Yes, good morning. So, yes, now, so what for now? I want to know. Hello?
Let's hit join so you can go into the breakout room with your lawyer. Hit join on the screen. Mr. Lopez,
Yes,
you have to go into the breakout room. You have to hit join so that you can talk to your lawyer privately.
okay.
He finally went into the room with Attorney Bashad. He just
Of
went in.
course he did. Can you send me back in perhaps?
I don't know how, I would have to recreate all the rooms. Do you know how to go, you can look on the bottom of the toolbar to go back into the breakout room? You know how to do that?
Let me see if that's possible. Yay.
All right, we're on the record. This is the People versus Jason Rice, 2260703. Mr. Rice is charged with count 1, robbery armed, count 2, assault with dangerous weapons, felonious assault. Count 3 weapons felony firearm. Count 4 weapons felony firearm today that they set for a preliminary examination of appearances.
Alexander Kirker on behalf of the people, P 86282.
And good morning, Your Honor. Neighborhood Defender Service, Beverly.
Right, state your full name for the record, please.
Jason Lee Wright.
Thank you. And are we ready to proceed today?
People are not, Your Honor.
Okay. Anything for defense? And defense is moving to dismiss as we are. Okay. Time is now 10:12. So I will dismiss, seeing that the people are not ready to move forward. I will start, I already signed it. So if you're happy with the clerk. Dismiss without prejudice, by the way.
Thank
Anything else?
No, Your Honor.
Okay. So, Attorney Reagan?
I am ready, Your Honor.
Who do you have today?
Judge, I have Juan Edgerson, Thomas Allen, Tadeo Sledge, and Marco Williams.
Okay, so all of them. All right, we have two ready to go, two here, check there. Let me address Attorney Michon's, it's just a PCC date, and then we can have the two gentlemen in county jail.
Thank you, Judge.
That's it.
Okay, Attorney Michon, are you ready on Lopez?
Ready.
This is the people versus Joel Lopez, case 2355170. Mr. Lopez is charged with attempted assault with intent to rob or arm, and count 2 weapons, felony firearm with a pneumatic gun. Appearance.
Alexander Kirker on behalf of the people, P 86282.
And good morning, Your Honor. May it please the court, Kim Michon, Neighborhood Defender Services, P 59167. I'm standing in for William Noakes with NDS, who is in a jury trial this morning. We do have complete discovery in the matter. We're asking the court to consider an adjourned PCC date to next Monday, as Mr. Lopez is having some medical issues and might not be able to be seen by Mr. Noakes. There may be a deputy in the booth with Mr. Lopez that might be able to shed some light on how long he will be quarantined for. My main concern is Mr. Noakes will not be able to see him unless the protocols have changed at the jail, which I assume is happening daily.
Okay. Is there a deputy nearby who can provide some insight to the court?
Mr. Lopez, is there a deputy?
Okay. All right, so,
Can you knock?
so just, okay.
Wait a second, don't say anything. Can you get, there you are. Good morning, sir. Can you tell us the current protocol in relationship to what is happening with Mr. Lopez, when he will be available to, 1, be seen by an attorney, and 2, be able to be transported to the 36th District Court for a preliminary exam?
At this point, he's on a 10-day period on the COVID unit, and he'll be retested after 10 days.
And as attorneys, are we allowed to see them on the COVID floor? Or are we allowed to schedule a video visit on the COVID floor?
Yes, the attorneys are allowed to see them.
Okay, beautiful. So Judge, whatever the court wishes to do, that'll give Mr. Noakes the opportunity to see him at least. But in order to bring him over to court, it sounds like we're gonna have to wait 10 days.
Okay, so I'll just keep it at January 30th. Does that work?
As a PCC, lovely.
Yes. And then at that time, Mr. Doe can let us know, what date for the preliminary exam.
Beautiful. Two other matters, Judge. One, would the court be kind enough? Normally, of course, I would be arguing the gentleman's bond, but I think I know this court well enough to know you're not going to reduce a bond without hearing something about the case. Would the court be kind enough to order that DSU for the next court date?
It's already been ordered. Should be ready for our next case, for our next date on the 30th.
Thank you. In addition, I would indicate that Mr. Lopez has indicated he is okay with his English. I have some concerns about that, Judge. We're going to ask the court for a Spanish to English, English to Spanish interpreter for Mr. Lopez, just to make sure, particularly when we're dealing with legal issues, that Mr. Lopez thoroughly understands what is happening.
Okay, I will agree with that. I will make sure we have someone available on the next court date on the 30th.
Thank you so very much, Judge, and a lovely day again to you and your staff.
Thank you. Mr. Kirker, do you have anything?
No, Your Honor.
Okay, all right. You have a question, Mr. Lopez, I will see you on Monday on Zoom.
Thank you, Your Honor.
You're welcome. Thank you. Officer Short, or- I want to handle the bond redetermination hearings, and then,
Oh, then we are.
and then we can take our time, so you know nothing else.
Oh.
Attorney Reagan, do you need to speak to anybody before we begin?
No, ready, Judge, ready to go.
Okay, I have, let's see. Margot Williams? Margot Williams? I can't hear you.
Yes, I'm Marco Williams.
Okay. Okay, we're on the record, this is People versus Marco Williams.
Here's a kind of time earlier for Marco. That's why it's not there. He already had a time signing for him. Let me grab the file.
I have the wrong part away.
Oh, okay.
You gotta turn check in already? Wait on the attorney.
It's a different.
So, Marco Williams. Okay, we're on the record, this is People versus Marco Williams, 2355250. Mr. Williams is charged with count 1, robbery armed, serious injury, count 2, assault with intent to rob or arm, count 3, unlawful imprisonment, count 4, weapons, felony firearm, count 5, weapons, felony firearm, count 6, weapons, felony firearm. Days and dates set for a bond redetermination hearing appearances.
Alexander Kirker on behalf of the people, P 86282.
And Your Honor, may it please the court, Philip Reagan, P 57156 on behalf of Marco Williams, who's appearing via Zoom from the Wayne County Jail, Your Honor.
Mr. Williams, can you speak up loudly and state your full name?
Marco Williams, Marco Edward Williams, Your Honor.
Thank you. Okay, whenever you're ready, Attorney Reagan.
Thank you, Judge. Judge, Mr. Williams was given an unaffordable bond on Friday of $750,000 cash with a GPS tether. Mr. Williams, Judge, is 18 years of age, no prior adult history, Judge. He's a lifetime resident of the city, lives with his mother, Judge, in the city of Detroit. So he has ties. He does have a child, Judge, that he resides with as well. Currently, Mr. Williams is severely disabled, Judge. He has pins and rods in his leg, on his whole right side, Judge. He is dealing with those medical conditions. He definitely falls within the 200% poverty guideline. He is not working. Because of his age, Judge, and the fact he lives with his mother, I don't think he's a flight risk, although this court has to look at possible danger to the community. I think if the court does house arrest with no ability to leave his home with a GPS tether, I would ask the court to consider a $750,000 personal bond with those conditions.
Your Honor, given the allegations of this case and the charges, the people would ask that bond remain the same.
Okay, after looking at his file, I am not inclined, Attorney Reagan, to adjust his bond. Only thing, once again, I will do, based on these type of charges and the possible danger to the community, is order a DSU report.
Thank you, Your Honor.
And I have here his next court date. Mr. Williams, you have a probable cause conference on February 1st at 8:30 a.m. It will be on Zoom. By that time, you should have a DSU report to be able to make a better determination on whether you should have your bond adjusted. You have a question, Mr. Williams?
Yes, ma'am. With my condition demands my physical therapy and visits to my surgeon on a regular. I got shot 11 times. My knee was shattered and my elbow was shattered. I have 10 rods in my arm. I have a plate in my arm. And if I don't visit my physical therapy and my surgeon on a regular, it can get worse. And my arm, the medicine I have been receiving in here, I've been in lots of pain. It has not been helping. I have not been receiving help to be getting transferred in and out of the bed. I don't have help being begged or anything like that. I just wanted you to keep that in mind for me.
Okay. You said you're not getting any help or any medical attention while in county jail?
Yes, I'm not. The only thing I have been getting is 800 Benadryls, and they're all 200 apiece, and they don't help. I need help being transferred in and out of bed. I am unable to where I cannot walk or use my right side at all. I can't use my right leg. I can't use my right arm at all. I can't weight bear on my right side at all. So I'm not a flight risk at all. and I have family, I have a stable family and heavy family that will make sure I make heavy court appearance, and I have a stable home that I can tether to.
When did this incident happen? When did you get injured?
I only been injured for a month, Your Honor, and I've been missing physical therapy and my surgery here, and I feel myself getting worse.
No, but
Like-
what date? The date that you got shot?
The date I was shot was December 3rd. I still have open wounds on my leg and my arm, Your Honor. And my nerve is locking up on me. I can feel it to where I can, like, I barely can move my arm, Your Honor, because I've been missing a lot of physical therapy. I missed multiple appointments being in here and multiple appointments with my surgeon. The medicine I'm receiving in here is not helping pain at all. I've been in pain all through the night and all through the day.
Mr. Williams, what I can do is figure out, I've never had this situation before, but, your file should be marked as medical first of all. And I'm gonna check with the Wayne County Jail to see what's going on, why you're not getting treated as a first issue. And then when we come back on the first, I should have better information. I should have different information about your treatment. But I'm going to make sure, your file is medical and that you should be getting, you said, tell me again, physical therapy, what else is going on?
And I have to visit my surgeon, Dr. Leonard. He's a doctor on Beaumont Farmington. I have to visit him on the regular. He's the one who did my surgery, because lately he told me he doesn't want my leg a certain way. I don't have, like, I usually have my leg propped up a certain way. My mom and them are always helping me. I can't take my regular medicine here. I'm in pain 24/7. And I also need my physical therapy. It's been feeling like my rods in my leg have been moving recently, like a lot. Like, it's starting to feel like my rods are beginning to try to disform or shift places in my leg. My knee was shattered and my arm was. I've been shot all across my body, Your Honor. The medicine here is just not enough.
Okay.
And Judge, if the court would consider house arrest, that we would ask the court to do so, Judge, with the tether, so he can at least go to his doctor's appointments.
I want to check with the county jail before I change my mind. I'm gonna do that today. And Attorney Reagan, if for some, actually, I know he's only supposed to get one bond return this year. But, after I check.
We're gonna put this over to tomorrow, Judge?
Yes, I want to check with the county jail.
All right, we can adjourn this till tomorrow, okay.
Do that. Mr. Williams, I'm going to get some answers before I make a determination to change my mind.
Okay, so I will have court tomorrow,
Yes, 8:30.
8:30 in the morning.
Yes.
Thank you, Your Honor.
Thank you, Your Honor.
Mr. Sledge? No. What's the gentleman, the other gentleman that's been waiting this morning? The other gentleman in the Wayne County Jail, can you unmute your device, please?
You know, Your Honor.
I'm fine. What's your name again, sir?
Thomas Cortez Allen.
Right.
February.
Okay, we're on the record as the people versus Thomas Allen, case 2. 25657-4. Mr. Allen's charged with 1 count of weapons carrying concealed. Today they set for bond, redetermination hearing, appearances.
Alexander Kruger on behalf of the people, P 86282.
Your Honor, Philip Reagan on behalf of Mr. Allen, who's appearing via Zoom from the Wayne County Jail.
Mr. Allen, can you state your full name for the record, please?
Thomas Cortez Allen Jr.
Okay, good morning.
Good morning, Your Honor.
And Attorney Reagan, whenever you're ready, you may begin.
Thank you, Judge. Judge, Mr. Allen, bond is currently $100. Judge, he missed a PCC back in January. He informed us that his house caught on fire. He lost a lot of his paperwork. I'm just asking the court, Judge, it's a CCW. I'm asking the court to consider 1,000 personal and giving him a new PCC date.
Anything for the people?
The people leave it to the discretion of the court, Your Honor.
Attorney Reagan, can you state again, you said $1,000 personal, what else did you, what was your request?
Judge, his bond right now is 1,010. I just asked 1,000 personal. That's all.
Okay, I will grant that request. I will change it to $1,000 personal. Mr. Allen,
Yes, ma'am.
I'm going to tell you your next court date.
I won't miss this one.
It is January 27th at 8:30 a.m.
At 8:30?
Yes. You do not need to be in person. Log on to Zoom, January 27th at 8:30 a.m. Courtroom
Okay.
138.
January 27th at 8:30?
Yes.
Okay.
That'll be for a probable cause conference, and at that stage, we will discuss any preliminary matters, any discovery issues, things of that nature, okay?
Okay, thank you.
You have an attorney that you've been speaking with?
It just says Reagan.
Mr. Allen,
Yes, ma'am.
you have an attorney?
No.
You have not spoken to one, okay?
You got Reagan.
Attorney Reagan, how does that work? Someone's assigned to him by the time his court date comes?
Judge, what's going to happen is that when you assign it, I believe that his attorney right now is let me see, is Ken Riggins. Riggins is his attorney, and Mr. Riggins should zoom back in on the PCC date, which will be the 27th. But this is signed right now to Mr. Riggins.
Okay, all right. So Mr. Allen, January 27th.
Zoom in.
That's
Zoom in
Friday.
January 27th at 8:30. Okay, thank you.
All right, you have a good one.
You too. Appreciate you.
You're welcome. Okay, for the other two gentlemen, we have Mr. Quan Edgerson and Tadell Sledge.
Correct, Judge.
Sir, with the glasses, unmute the device and tell me your name, please. Sir, if you can unmute your device, please, in the Wayne County Jail, state your name. Can someone from the Wayne County Jail assist this gentleman right here and unmute the device so we can call his case, please? Sir, what's your name?
T-Dell Sledge.
Thank you. Is the People versus Tadell Sledge, 2355247. Mr. Sledge is charged with count 1, assault with intent to murder, count 2, assault with intent to do great bodily harm, less than murder or by strangulation. Count 3, assault with a dangerous weapon, felonious assault. This is a habitual offender, second and fifth notice appearances.
Alexander Kirker on behalf of the people, P86282.
Your Honor, Philip Reagan on behalf of Mr. Giselle Sledge, who's appearing via Zoom from the Wayne County Jail.
Mr. Sledge, can you state your full name for the record, please?
My name,
Yes, your full name.
T.D.L. Dante Sledge.
Thank you. Whenever you're ready, Attorney Reagan.
Thank you, Judge. Judge, Mr. Sledge is 45 years of age. He was given, Judge, on Friday, an unaffordable bond of $500,000 cash for surety with a GPS tether. Again, 45, Judge. He has no pending cases. I can see, Judge, he's currently on Social Security income. He gets a fixed income every month, Judge. He's also taking several medications from Haldol and Cogentin, Judge. I would ask the court, understanding these are very serious allegations, Judge, but I would ask the court to consider some type of reduction, no contact with the complaining witness in this particular matter. Judge, he is charged with 3 charges: assault with intent to murder, assault with intent to do great bodily harm less than murder, felonious assault. These are all charged against Judge a Nicholas Gray. It looks to be, I'm sorry, Kashmir Gray, who looks to be the complaint. Now, Judge, just in saying that he's charged with all 3 charges, this very well could be a felonious assault when it's all said and done. Not saying it'll be anything. I'm not saying it'll be anything, but it could be a felonious assault, a 4-year felony, Judge. So I'm asking the court to take that in consideration as well. So I'm asking the court to consider reduction in bond, Judge, with the GPS tether.
Mr. Kirker.
Your Honor, considering the allegations, we do have a concern over community safety and would ask that bond remain the same in this case.
Okay, Attorney Reagan, with this case as well, based off of the possible danger to the community, complaining witness, I see in here information about large lacerations to the throat. What I will do is order a DSC report. Mr. Sledge's next court date is the 31st. Today is the 23rd. DSC report should be ready by that time. So what that means, Mr. Sledge, is I am not changing your bond at this time. But when you come back to court on the 31st for a probable cause conference, I'll have a report that will give you more information that in the event that your attorney wants to address your bond, I will be able to make a better determination or better decision. Okay? You're on mute. I can't hear you, just so you know, Mr. Sledge. Mr. Sledge, can you have someone come to unmute your device, or can you go ahead and unmute on your screen? I don't know if you can do that. I want to give you your next court date. I want to make sure you hear it. I can't hear you. You're on mute. Okay, Mr. Sledge, your next court date is January 31st at 8:30 a.m.
8:30 a.m.
Yes, and it'll be on Zoom, and you'll have a different attorney, and I'll have a report that will give you more information about your background and the circumstances of this case. And if your attorney wants to address about it at the time, he or she can, okay?
Okay.
All right, got anything else, Attorney Reagan?
No, Your Honor, thank you.
You're all set, Mr. Sledge.
Okay, thank you.
You're welcome. I have a Quan Edgerson.
That's the last one I have, Judge.
Me too.
Y'all doing?
State your name, sir.
Quan Edgerson.
Okay, this is People versus Quan Edgerson, 2355267. Mr. Edgerson is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation, and this is an habitual offender, second offense, no, excuse me, appearances.
Alexander Kruger on behalf of the people, media 6282.
Judge is praying on behalf of Mr. Edgerson, who's appearing via Zoom from the Wayne County Jail.
Whenever you're ready, Attorney Reagan.
Judge, thank you. Mr. Edgerson, Judge, is 36 years of age. Currently, Judge, he is not on probation or parole for anything. He lives in the city of Detroit, Judge, has pretty much his entire life been here. He currently receives a fixed income, Judge, of Social Security every month. He is currently on medication right now, Judge, which I'd ask the court to consider in his bond. I'm asking the court, Judge, to consider a reduction. His bond currently is $50,000 cash. I'm asking for $50,000 personal, Judge, with no contact with the complainant, Alan Rosetto, as well as the court feels necessary a GPS tether, Judge.
Mr. Kirker.
Your Honor, people without step bond remain the same in this case.
Mr. Attorney Reagan, is it your understanding that Mr. Edgerson and the complaining witness live in the same location?
Judge, Mr. Edgerson, is it true that you and the complaining live in the same location?
We did, yes, we did, yes. I wasn't anymore, but yes,
Not
we
any
did.
longer, correct?
Right.
So Judge,
No.
so there's no reason for any contact at this point, none, zero.
No, it's not.
Attorney Reagan, I'm gonna do the same thing because of the assaultive nature of this case
Yes, Your Honor.
and the injuries. I am going to order a DSU report for his next court date. Anderson, is that I am not reducing your bond at this time. I'm going to ask for more information and details on this case, someone who, or agency that can provide more information about your life and the nature of this case. And then I can make a determination at that time whether or not I want to change your bond. So your next court date will be January 31st. That will be next Tuesday at 8:38, I'm sorry, 8:45 on Zoom, okay?
Okay. Is it?
Thank you very much, Your Honor.
Did you have another question, Mr. Edgerson?
No, that was it. I was wondering, was that it?
That's it, yep, you're all set.
All right, thank you, man.
You're welcome. Okay, Attorney Reagan, you're all set, right?
Thank you very much, Your Honor. Yep.
All right, you have a good one.
You and your staff have a wonderful day. Take care, be safe, Judge.
You too. Attorney Reagan. Getting ready to start the exam.
Yes, good morning, Your Honor. I do apologize for the delay. They assigned me, but I didn't have any information or the court information, even the judge. So I do apologize.
Okay, you ready to go, Mr. Dorsey?
I am, Your Honor. We're just obviously adjourning for discovery today.
Let's talk about that. Okay, this is
Okay.
Mary Dorsey, 2355191. Mr. Dorsey is charged with one count of police officer assaulting, resisting, and or obstructing. Today they set for a probable cause count.
Alexander Fisher on behalf of the people, P86-282.
May it please this honorable court, Darnell Barton, P83363 on behalf of Mr. Dorsey. Sir, can you state your name only for the record, please?
Damari Dorsey. Damari J. Dorsey.
Thank you. Okay, Attorney Barton, is it correct you said you were just assigned to this case?
Yes, that is correct, Your Honor.
Okay, Mr. Kirker, how long do you think it will take to provide, I'm assuming digital and paper?
It was sent over to the previous council on the 19th, so it could be sent over this afternoon.
Did you hear that, Attorney Barton?
I did not. I apologize.
Mr. Kirker said it could be sent over today. It was already sent to the previous attorney, so it's actually ready to go.
Okay, sounds good. I just put my email in the chat just in case.
Okay, since there's no issue with obtaining the discovery, I would like to set an exam date, if you're comfortable with that. And if there are any discovery issues, I say maybe a week before the exam, you can call to the court. I don't think that should be an issue, but we're already in mid-February.
Sounds good, Your Honor.
Okay, so I have February 10th and February 13th.
One moment, if I may, Your Honor.
Okay.
Hello.
Okay. If I may do February 10th, is that the morning, Your Honor? February 10th in the morning?
Yes, I have 9:30, and 10:30 available.
Yes, I would. I think that would work. I'd appreciate that. Thank you.
Okay, which time do you want? 9:30, or 10:30?
Oh, I'll take the 9 a.m., Your Honor.
9 a.m.
Yes.
Okay, Mr. Dorsey, did you have a question?
Yes, ma'am. At this time, I would I want to know if I could request to get my tether off or be off house arrest. I'm currently looking for a job. I'm not a flight risk. I'm not a flight risk or anything. It's my first offense. Yes, ma'am.
Yes, sir.
You want
I'll
your
go ahead.
Mr. Attorney Barton, do you want to talk to your client in private?
Yes, Your Honor. I would like to, if possible.
Okay. Mr. Dorsey, I'll let your attorney do the work, okay?
Okay.
There you go. What's up?
Go ahead and hit join, Mr. Dorsey. Check out our
Your Honor, is he still?
This is bro.
Oh, okay.
I want to start scheduling. Like Phil said. Attorney Roberts, good morning.
I
Good morning. Can you hear me okay?
yes, I can hear you. Can you hear me? Thank you.
Who are you here for today? Mr.
I am here on, yes, Mr. Maurice Estelle for a preliminary examination at 11:15. I am still in Judge Thomas's courtroom in Frank Murphy waiting to be called. I expect it might take up to another 30 or so minutes. So if,
That's fine.
okay, thank you, Your Honor.
Stand out.
Thank you. I'll be there as soon as possible.
Okay, thank you for calling. Okay, Attorney Burton.
Yes, thank you, Your Honor. So I got his information. We're ready. If it's okay with the court, or may it please the court, I'd like to address the bond for Mr. Dorsey.
Okay, we're back on the record, People versus Devari Dorsey. Whenever you're ready, Attorney Burton.
Thank you, Your Honor. After speaking with my client, Your Honor, I've spoken with him, and then you weren't able to see, but his mother and his stepfather were actually in the background with him, very supportive. The young man also is 19 years old, and he has no criminal record whatsoever. I believe they placed a tether on him because they thought he might be a flight risk due to the circumstances of the event. However, after speaking with him and his mom, knowing he has no criminal history whatsoever, he's about to be enrolled into school soon. He graduated high school already. With that said, Your Honor, I would respectfully ask that he be released with the personal bond without the tether, one, from the cost, and two, from the fact that he is not a flight risk again, and he's not a danger to society. I don't think even the charges themselves were assaultive in any way, even though it describes as resisting an assault. So with that said, Your Honor, I just would request that they remove the tether from him. He will, in fact, appear at every court appearance, just as he did today. And I've spoken with his mom and the stepfather, and they are 100% on board. They will take full responsibility for making sure he appears. Thank you.
Mr. Gregory?
He believes the discretion of the court.
And I'm sorry.
Go ahead, Mr. Burton.
I may just very briefly on this one, Your Honor. Again, it's the nature of the charge and what occurred, what they're alleging that occurred, that would, if I were in the court's position, be hesitant to remove it. However, after discussing with the parents and seeing what's going on, that the allegation is that they got up and left the vehicle, and there were several young men in the vehicle. Him being one of the young men that has a very huge family support system, and they're disappointed in the fact that we're even here. And I think that's going to get us a long way in the court. So with that said, I just would respectfully ask that we remove that, allow him to go into these jobs and to this school without the tether bulging from his leg, Your Honor. That's all. He has no criminal history whatsoever.
May I ask Mr. Dorsey about his schooling?
Yes, I'm sorry. Did you say, may you ask him about his schooling?
Yes, I want to make sure.
Please.
Okay.
His mom, yes, his mom is trying to register him now. Him and his mom are registering for a technical school. He's not looking for college per se. He's looking for a technical position, Your Honor.
Mr. Dorsey, what school are you enrolling in?
I was trying to get into Dorsey school, Dorsey college schools, or anything trade, likewise, I should say. Like I was trying to get into a trade, learn new.
When are you applying?
I haven't applied yet, Your Honor, but this is something I've been looking into.
When are you applying?
When, young man? When?
Huh? Oh, as soon as possible. As I can.
So are you and your mother, let's make this a little more clear for the judge. How soon are you and your mom going down to the school specifically? I know you've been in contact with the school from speaking with your mom, but how soon are you guys looking to go down there and actually register yourself?
Can my stepfather speak for me really quick? Would that be okay?
I don't know if the court would allow that. But essentially, if your father can just tell us, we're looking to get down there at this time, et cetera, et cetera. We're just trying to. I'm sorry.
Attorney Barton, are you okay? We actually have the 30th open for an exam. We can do we can do it actually within a week.
Give me one moment, Your Honor. I'm in a few courts that Monday, Your Honor. I can try to come in, but I know it wouldn't be till. Well, I could try and rush in the morning, 8:30. If not, I have a huge civil rights case. I'm sorry.
You could be the first, and it's no exam actually scheduled for that day for some reason. So you could be the first exam at 8:30.
Okay, my only concern with that, Your Honor, and I know I don't want to belabor your court, is that if we have to hold that exam, then I'd be at a disadvantage, if that makes any sense, because I'm gonna have to rush out of there, if that makes any sense. But you know what? Let's do it. No, we'll make it happen, because what I'm gonna do. No, I already know what I'm gonna do. Let's do that if we can. I'll set it for the 30th. And then I can have discovery as soon as possible. I don't want to belabor the court. Let's do that. If that will work, Your Honor, I would appreciate that.
Okay, with the earlier exam date, I'm more inclined to, I will have your tether remove Mr. Dorsey under one condition. I need you to bring to court also your application for the technical school.
Absolutely.
Okay.
And,
If the judge wasn't clear, son, you young man, I'm sorry, you have 1 week to get that application to bring it into court. Okay.
Okay.
Sorry, I didn't mean to interrupt.
Not blank either, Mr. Dorsey. I need it filled out. I need a copy of it because you already submitted it, or I need it filled out and ready to be submitted.
Yes, ma'am.
Okay, so we've changed your preliminary exam date to January 30th at 8:30 a.m. Mr. Carter, is that gonna be difficult for you?
I wouldn't know until we send out subpoenas.
Okay, but you can be here. Right?
Yeah.
Okay, this is a rare, for some reason, a doctor.
Yeah.
Okay, all right, so I will see you, Mr. Dorsey. I will put on here to remove your tether. And you will be on the personal, you're out on the personal bond already. As long as you show up on Monday at 8:30, courtroom 438 in person, you should not have any problems along with that application to school, okay?
Yes, ma'am. You said it's in person, right?
In person, yes.
Okay. Thank you.
Right. Okay, thank you, Your Honor, to you and your staff. You guys have a wonderful day.
You as well.
Oh, and I'm so sorry. This is the first time seeing you. Congratulations once again, Your Honor. It's my first time seeing you since then. Congratulations.
It's 7
Absolutely.
months.
Has it been already? Jesus. It flies by. It flies by. Anyway, and congratulations. You guys have a great day.
You as well. Mr. Dorsey, I'll see you on Monday.
Okay, thank you. See you later.
Okay. School is more. Yeah.
There you go.
We are on the record, this is People versus Reva, Felicia Tompkins, case number 2261058. Ms. Tompkins is charged with count 1, police officer assaulting, resisting, and or obstructing. Count 2, malicious destruction of personal property less than $200. Appearances.
Alexander Kirk on behalf of the people, P862882.
Good morning, Your Honor. Vanessa Hamilton, P82107, on behalf of Ms. Tompkins. Ms. Tompkins is not present today in the courtroom. I have been unable to contact her. Her phone is off and my text messages are not going through for any of that nature. If Your Honor is inclined to give us additional time to have an investigator try to seek her out, and would it kindly adjourn this date, we would accept it. Otherwise, we understand.
Anything from the people?
Your Honor, we would move for case here.
Okay. So I will issue a case, but it'll be a personal. With $1,000. You're welcome. And just for the record, the time is 11:06 and the exam scheduled for 10:30. This is the recall of People versus Security Hawkins appearances.
Alexander Kirker, I'm an alpha vehicle P86282.
Neighborhood Defender Service by Cheryl Quick, P83973, on behalf of Corey Hawkins. Mr. Hawkins is present.
Mr. Hawkins, one more time, state your name.
Where you looking?
Thank you. And are the people ready to proceed?
They are.
Okay, any preliminary matters?
None from the people.
Maybe just move for sequestration. I don't see anybody in the courtroom, but for the record.
And for the record, there is no one else in the courtroom, not even the OIC. So with that, Mr. Kirk, you can call your first witness.
This time the people call Officer Deshaun Perry.
Sean. DESHA.
You first tell us who's going to do that. All right, have a seat and make sure you speak up. Whenever you're ready, Mr. Kirk.
Morning, please restate your name for the record.
Deshaun Perry.
And are you currently employed?
Yes.
Where are you currently employed?
Detroit Police Department.
And in what capacity?
Police officer.
And how long have you been employed as a police officer?
Almost 3 years.
Were you employed as a police officer on August 30th, 2022?
Yes.
Did you in fact work on that date?
Yes.
Were you by yourself or with a partner?
Partner.
And what is your partner's name?
Officer Flannel.
And were you in full or modified uniform?
My father.
Can you describe the uniform?
Black carrier, vest carrier that said Detroit Police on the front and the back, and green pants.
Were you on foot patrol or in a scout car?
In the scout car.
Is it a fully marked or semi-marked scout car? Did your duties as a police officer take you to an area at or near 190994 Porter Street?
Yes.
Is that in the city of Detroit,
Yes.
county of Wayne?
Yes.
And what brought you to that area?
Just routine patrol.
Did anything happen while on this routine patrol on that date?
Yes.
And what happened?
On that night, it was a severe power outage. And I was driving west on 7 Mile past Foyer. While driving, I observed 2 males standing in the street. I turned around to really just check on them. At that time, when I drove north on Foyer.
And when you say check on them, for what purpose were you checking on?
I was just checking on their well-being. I wasn't sure why they were standing in the middle of the street. I drove north on Foyer from 7 Mile. At that time, I observed a male wearing a blue hoodie and black pants, walk away from the males.
And do you see that individual in the courtroom today?
I do.
Could you point them out and identify an article of clothing that they're wearing?
I sent behind the defense counsel wearing a black polo shirt.
Your Honor, this record reflects the identification of the defendant. And what happened when you saw this individual?
After he observed scout car, he began walking south on Foyer towards 7 Mile. At that time, I observed Officer Funnel exit the scout car and attempted to engage the male.
And what happened after your partner attempted to engage the defendant?
I got out of the car and came around the back of the car from the driver's side. And once I came around, I observed the male holding a firearm in the pants of his pants.
And can you describe that, what you saw, the firearm?
Yes, it was a longer firearm. Like I could see the imprint of the firearm bulging through his pants. And he's holding it with his right hand.
Did you see any of the firearms sticking out of his pants?
I could see the handle of the firearm.
And can you describe the handle of the firearm?
I think it was a black handle. Not sure.
And what did you do after making this observation of the firearm?
Like I said, I observed also one attempt to engage him, and and the male ran, Bill a couple feet away. And I engaged the male, ordered him to take his hand off the firearm.
Did he comply with your orders to take his hand off the firearm?
Eventually, he complied.
And what happens when you caught up to the defendant?
Eventually, I took the firearm from out of his hands and taken him in handcuffs.
And did you ask the defendant if he had a CPL?
Yes,
Did the defendant provide a CPL?
he did not.
Did search warrants to determine if the defendant had a valid CPL?
Yes,
And what were the results of that?
negative, no CPL.
And was the weapon placed into evidence?
Yes,
Do you know the evidence tag number?
yes, I believe it was 681-935. That's one.
Officer Perry, it was about 12:30 in the morning on the 30th of August, is that right?
Yes,
So it was dark out, right?
correct,
You said there was a power outage?
correct.
I imagine there was no street lights directly overhead.
I believe so.
You said that you and your partner were traveling to the eastbound on 7 Mile?
West on 7 Mile, passing border.
Okay, and so 4 would have been on your right side?
Yes,
Okay, because you were the driver, right?
correct,
Okay. And so you would be looking past your partner out his window to see that side of 4?
correct,
Okay. You said you were driving in a semi-marked scout car?
yes.
What does that semi-marked scout car look like?
It's a black scout car with a Detroit police on the side.
Okay, and it's in dark writing, right? Gray writing?
So,
The Detroit Police Department on the side, that writing is dark gray?
it was gray, yes,
Okay. And you said that you saw out the window a group of young men on 4?
yes, in the street.
They were actually next to a parked car, isn't that right?
I believe so, close to the middle of the street, though.
Okay. And you said that you saw one of the men walking down the sidewalk away from the others?
After I turned north on 7, I turned around and turned north on the foyer from 7 Mile. At that time, I observed the male walking away from the mills.
So y'all turned onto 4, it would have been a right-hand turn on 4?
No, at that time, I was going west, I turned back around to go east, and I made a left turn onto the foyer.
So after you saw the young men, you actually did a U-turn
Yes,
and then pulled left on the 4
yes,
and stopped your scout car in the middle of the street?
yes,
Okay. And you said that at that point, Officer Flannel jumped out of the car
correct.
and chased after the individual who was walking away.
Yes,
And Mr. Hawkins, or it ended up being Mr. Hawkins, is that right?
correct,
Mr. Hawkins then changed direction from your partner?
yes.
Is that when you got out and you chased?
Now, so before the chase began, I took the scout car and approached the male as well. And at that time, he was walking south, he ran back north. And hopefully,
He was walking south when your partner attempted to engage,
correct,
and when that happened, you turned and started walking back north on 4?
correct.
And then you said you got out of the scout car, came around the back?
Yeah, before I got the scout car and engaged, I went to approach the male as well. At that time, he still was walking south, but after he seen me, he ran back north.
Okay. And this whole interaction lasted less than a minute, right?
Less than a minute, yes,
Close to 30 seconds, really, right?
yes,
And so Mr. Hawkins didn't get very far, right?
No.
Took a couple of steps
yes,
and then you got to him
correct,
and he ended up on the ground, right?
correct.
I don't believe that is any further questions, Madam. Redirect.
How close were you to the defendant when you first observed the firearm?
Maybe 10 to 15 feet.
What was the lighting like when you observed the firearm?
I said, I'm not sure. I was able to see him clear as day. I'm not sure if I illuminated him or not. I possibly used my flashlight, but I can't tell. I'm not sure.
No further questions.
Just one based on that. That was while you were already out of the scout car,
Yes.
right? So it's possible you may have like shine your flashlight on it.
It's possible, yes.
Nothing further.
Any other officers or any other witnesses?
No further witnesses.
No witnesses, right?
Okay. And just for the record, the officer in charge,
Yes, this is the officer in charge.
and your name on the record.
On the officer in charge.
You go ahead and put your name on the record. Detective Vanessa Burke. Okay, because we started the exam, you weren't here, I just want to make sure it's on record that you were now here. That you were here for full testimony for Officer Perry. Yes, okay. All right, whenever you're ready, Mr. Parker.
And at this time, we would move to bind over the defendant on count 1, weapons carrying concealed. As you heard from the witness, the officers that night, it was a severe power outage. They saw several individuals standing outside of the vehicle. Based on their caretaking function, they were concerned for their well-being. Performed a U-turn, came around to engage with the individuals. But first, Officer Perry's partner, Officer Flannel, engaged with the defendants. And then when the defendant began walking away from his partner, Officer Perry, the witness, exited the scout car. As he testified, he was able to see there is a what he believed to be the outline of a firearm, a long firearm, as he described, as well as the handle, a black handle sticking out of the appendix area. He was able to recover that firearm from the defendant. So at this time, he then asked the defendant if he had a valid CPO. The defendant did not provide a valid CPO. A lien search was conducted to determine if the defendant had a valid CPO. Again, the results came back negative that he did not, the defendant did not have a valid CPO. So at this time, the people believing that they've heard the probable cause and asked to find out the defendant to the case.
Your Honor, we object to the bind over. There was no evidence that there was any reasonable suspicion for the officers to stop Mr. Hawkins or anybody he was with. To establish reasonable suspicion, there must be some articulable, unparticularized or particularized suspicion beyond a hunch or suspicion of some kind of criminal activity. Officer Perry testified that he was participating or doing a community caretaking function. However, there's nothing significant about a couple of young men standing next to a parked car on the street. That there's no testimony that it was not legally parked or that there was something suspicious about that car. We don't know if it was just two people getting out of a car or three people getting out of a car and walking towards a house. There's just testimony that there was a couple of young men next to a parked car on the side of the floor. The next thing the officer testified to was that he was in a semi-marked car, which means it's a black car with dark writing at a night where it's 12:30 in the morning, it's dark outside, and there's no overhead lights. There's no street lights from the street because of the power outage. So there's no can't impute on Mr. Hawkins any knowledge that he was walking away as police were pulling up. There's no evidence that he would have even known that those were police officers pulling up. And then one of them jumps out of the car and starts walking towards him. He doesn't have to cooperate. And even if he did, a refusal to cooperate without more does not furnish the minimal level of objective justification needed for a detention or a seizure. Mr. Hawkins has the right to walk away. There's no reasonable suspicion. He doesn't have to submit to Officer Flannel. And that's based on Florida v. Boston. That's at 501 US 429. Even if the court were to believe that Mr. Hawkins did see that it was a police car and he was trying to walk away without anything else, flight is not indicative of wrongdoing and it's not enough to justify an investigatory stop. This was officers seeing a group of young men on the street and wanting to stop them and see what was going on. They've got to have evidence of some kind of criminal activity in order to stop somebody. Officer Perry testified that it wasn't until after he got out of the car, and after his partner had already kind of given chase to Mr. Hawkins, that he saw the firearm. So that's not even the basis of the stop. It wasn't until after they started to attempt to chase Mr. Hawkins down that they saw what they said was the handle, that he saw what he said was the handle of a gun. We don't know what Officer Flannel may or may not have said to Mr. Hawkins when Officer Perry said he engaged. Did he say stop? What did he say? We don't know. So we don't know if any lawful commands were actually given. I would point to the court towards U.S. Davis, which is at 554 Federal Appendix 485. It's a Sixth Circuit Court of Appeals case. There, the court found that officers left.
Sorry, could you say the case?
Sure. It's U.S. Davis, and it's 554 Federal Appendix 485. There, the court found that officers lacked reasonable suspicion to stop someone merely because they had observed a bulge in his pocket. And there, that's officers testifying that they actually had seen something. In that case, the defendant was just walking, and the bulge, the court said, could have been anything. So even seeing something that officers thought might have been suspicious was not sufficient for reasonable suspicion. Then finally, I would point the court towards well-known case in Michigan, People v. Shabazz, which is 424 Mich 42. There, the court found that officers did not have particularized reasonable suspicion for an investigatory stop. You have a man who's present on the street late at night in a high crime area, in front of a building or having just left a building that was known for narcotics and contraband, and he was carrying a small paper bag. He fled from the police, and the court still found that there was not reasonable suspicion. And in this case, we have not even a fraction of that. We have simply Mr. Hawkins walking away from a parked car, having done nothing to incite any kind of suspicion of criminal activity.
Just simply that officers are used to perform a caretaking function, and they are permitted to walk up to individuals and engage them without needing to have reasonable suspicion, just to engage in the conversation. In this case, the officers they testified to was 12:30 at night. There was a severe power outage. There were several people standing outside. They wanted to first and foremost check up on and see if everything was okay, if they could assist in any sort of way. It was only after the defendants began first walking away from the witness's partner, and then approaching or looking toward the witness, where he then saw the handle of the gun sticking out of the defendant's hand. At this point, he then engaged in for a stop. So we would argue that this is enough for a probable cause.
Okay, the court heard testimony from Officer Perry that he was in a modified uniform black vest with police written on it and green pants. Officer Flannel was in a vehicle, semi-marked vehicle that was doing routine patrol on a night, I believe August 30th, 2022, when there was a power outage. It was around 12:30 a.m. Testified that it was dark outside, and that there were males in the street, and Officer Perry was checking on them for their well-being. That the defendant, Mr. Hawkins, was observed walking away from the group of males, and Officer Perry also testified that the defendant observed the scout car, and that, Officer Flannel, Mr. Perry, or Officer Perry's partner, tried to engage the defendant, and that is when Officer Perry eventually saw the defendant holding a gun in his appendix, and that it was bulging out of his pants, and that he saw a black handle outside of the pants, and that's when the defendant ran and fell a couple feet away. Officer Perry then took the firearm, handcuffed him, and asked the defendant if he had CPL, and the answer was no. So the question or the issue here, Attorney Quick, as counsel has brought to the court, is that of whether there was reasonable suspicion for Officer Perry and or his partner to engage in apprehend. The facts here, we have 12:30 at night power outage in the city of Detroit. And we have gentlemen in the street. We don't know for what reason. And Officer Perry testified that he was there to check on their well-being. We don't know why the defendant and other people he was around were in the street. And then the defendant just walked away. He didn't run away. He didn't say anything. He just walked away. And based on that, Officer Flannel engaged and began to apprehend Mr. Hawkins. I have an issue with that part of the testimony because Mr. Hawkins didn't do anything wrong as far as walking away. And Mr. Kirk, as you stated, that's true. Police can engage, police can talk to people, nothing wrong with that. But it was more than talking to Mr. Hawkins. At no point, I don't think the testimony stated that Officer Perry stated that anyone said, "How are you doing? Are you all okay? Do you want any help?" Of course, there was a firearm recovered, no CPL. But whether it was a hunch or not, I don't believe that there was reasonable suspicion to apprehend Mr. Hawkins based off of him walking away from a group of people at 12:30 at night in dark when a power outage officers in a semi-marked black vehicle at nighttime in the city of Detroit. So with that, I am not going to find this over in this agenda.
Okay. So here. What she was saying. I'm not sure. Yeah.
Here's one up here. So you probably can check the right box, but it's- Wait outside.
Yes, good.
Okay, thank you. Good afternoon.
Yeah, are you in a case here with this topic? Are we cases? Defendant was Tompkins. I think she's. Yeah, she on Zoom. The attorney said she was on Zoom.
There's nobody.
Okay, cool. No one showed up. Where's the? How you? Good. Miss Valerie.
Oh.
That's wrong. That's
11:30.
11:30. Might be early.
You're on time.
Trying to see if they're, oh, okay, if they're ready to see that.
Okay.
Mr. Hunter's up here. Mr. Hunter is up here. Mr. Notes up.
I don't know why I thought we did Hunter already.
No, that's earlier.
What happened with Simpson? Marvin Simpson? Nobody checked into it?
No, no one checked in for Simpson yet. Did they? Yeah, I don't think so, no. Yeah, Marvin said that's a proper cause.
Oh, Judge, that place is taken to the gate. That's what I thought.
Oh, okay.
Thank you.
Oh, yeah. Yeah.
Brian Jackson.
You're ready on Brandon Jackson.
They are?
Yeah. Everybody's here.
And Hunter's back.
And Hunter's in like a.
Okay, so we need to see which takes.
Yes, we can do Mr. Hunter, Your Honor, we realized over the weekend there's a conflict with the witnesses, so my office.
Okay.
My partner over there.
Oh,
Today, I would imagine today that today is fine. Yes, yeah. Okay. And I know she gave the rest of the website. That was one we did.
Oh, yeah.
Yeah. We're ready.
Thanks, sir. Oh. I didn't know you.
Hold on a second.
Ready. Go. So you might as well go ahead.
Probably know who I am. Or what to do inside here.
You run the record, is the people first. Oh, I'm sorry. Thank you. Okay, we are on the record with the people versus Travis Demar Hunter. Case number 2355003. Hunter is charged with count one, assault intended to rape by harm less than murder or by strangulation, and count two, assault with a dangerous weapon, or assault. This is an habitual offender report, that's been notice. Oh, this is- Okay, and this Hunter's second case. 2355004. People versus Travis Jamar Hunter. Mr. Hunter is charged in this case with count one, assault with intent to murder. Count two, assault with intent to do rape, bodily harm less than murder or by strangulation. Count three, assault with a dangerous weapon, one is assault. This is a habitual offender report, which is notice dated date set for preliminary examination appearances.
Alexander Director on behalf of the people, PDA 6282.
And may it please the court, Neighborhood Defender Service of Detroit by Jeffrey Knupke, P64800 on behalf of Mr. Hunt. Mr. Hunt, state your name.
Good morning to everybody.
Good morning, Your Honor.
Okay, and brought to my attention that this will probably not do the report today.
That's correct, Your Honor. And in reviewing a visit over the weekend with my client and our investigator and reviewing the discovery and going over kind of various allegations, we came across the name of a witness that was involved here, and in checking on that witness, we found out that my office, Neighborhood Defender Service, actively represented him just recently on a couple of cases, and based on the information that would be to Mr. Hunter's benefit, it would perhaps require us to use information that would be against our other clients' best interest, putting us in a conflict position.
Okay. So your office is asking to withdraw.
Yes, Your Honor.
And without getting into too much detail, I believe you told me everything you could, correct?
Yes, Your Honor.
Okay. Already got the clerk, go ahead and call across to third circuit to appoint him another attorney based off of what you told me before we got on the record. And you received all the discovery, there were discovery issues.
I believe we have, I mean, there may be some medical records and things that are outstanding, but as far as discovery right now, I believe that we do have everything. I did provide paper copies to my client this morning, and if there was a mix-up or an issue with the attorney, at least to be able to start there. But I also gave my name and my numbers on there so that he can give the attorney my information, and I can send what I have.
Okay, and Mr. Kirker, you don't, there's nothing or no issues with discovery.
At this time, I did not believe so.
Okay, Mr. Hunter, do you understand what's happening?
No.
Okay, so, we were supposed to hold your preliminary exam today, you do understand that, right?
Right.
Okay, so if you were to be represented today by Neighborhood Defender's Office, there would be a conflict of interest that would not be in your best interest based off of someone that they've represented already. You understand that? So because of that, I would allow for the withdrawal and appoint you an attorney who would not be in conflict and can represent you to the best of their ability to give you a fair opportunity for it. You understand that? Okay, so what I'm trying to do is figure out how soon, I want to do this as quick as possible because you're in custody. You need to a new attorney to have discovery sent to your new attorney so that we can hold your exam. So that's why I'm asking about the discovery issues. If there aren't any, so we can do this very quickly, okay? So the clerk has already called to try to get you a new attorney. They're going to come visit you just as your other attorney have done, or I don't know if you've had multiple. And we're going to have a PCC, a probable cause conference, to make sure everything is fine. And I will schedule your exam, preliminary exam 1 week from that date, okay? So give me one moment so I can see how long it's going to take for an attorney to be assigned. And if possible, maybe they can zoom in now. I don't know if they're available. Just give us a call. Okay.
Yeah.
Yeah, I just want to make sure. So we're back on the record, for the record, we're waiting for the attorney to log on. We're on the record, this is the People versus Tyrone Valentine, 2259753. Mr. Valentine is charged with 1 count of weapons carrying concealed. Appearances.
Alexander Kruger on behalf of the people, P 86282.
And good morning, Artie Chambers on behalf of Mr. Valentine, who stands behind me, my P number 63956.
And Mr. Valentine, can you state your full name for the record, please?
Tyrone Lee Valentine.
And today's date set for a preliminary examination. Are parties ready to proceed?
Dismiss ready.
People are not, Your Honor.
Is there a response from fifth?
Move for dismissal, sir.
The time is now 11:48. That was scheduled for 11:30 this morning. See that the people are not ready to proceed. I will dismiss without prejudice.
Thank you, Judge.
You're welcome. Here is your form. All right.
No, you. She good. All right, yeah. Never showed up. Oh, there it is. Oh, okay.
Attorney Cross? Good morning. Is it Cross?
Good morning.
I can barely hear you.
I can barely hear you, Judge.
Okay, let's see. I can hear you better.
No.
Wait a minute. Do you have another one? Another remote that's open?
He said don't touch that.
That's what I said. I was wondering if they were testing.
Oh, yeah, I touched it.
Okay.
How about now?
I can hear you better now.
Okay, great. Robert, are you here for Mr. Hunter?
Yes, I was just got appointed.
Okay. So I will recall the case and kind of give you a little bit of background and what we're gonna do, or try to do. Okay, we are back on the record, People versus Travis Jamar Hunter. Two cases, we have 2355003 and 2355004. Mr. Kirker is the prosecutor of the case. He's in the hallway. I'm sure getting ready for the next cases. I'll have current defense counsel and Mr. Hunter put their names on the record, and then we'll have Mr. Kirker come in. This is for reappointed counsel. Anything to your pleasure? Do you want?
I could be.
Okay.
Just so I, just set this up for you.
All right. Well, what is your appearance?
Alexander Kirker on behalf of the people, PA6282.
Jeffrey Kaneki, P64800, MGS Detroit, on behalf of Mr. Hunter. Mr. Hunter, state your name, please.
Robert Hunter.
And Attorney Kraus?
Good afternoon, Sarah Kraus, P81830.
Okay, it has been brought to my attention that NDS can no longer represent Mr. Hunter based on conflict of interest. So I explained that to Mr. Hunter on the record, but of course, you want to go way more detail about that if you need to. At this point, I am going to withdraw NDS now that it has counsel available. So what we're trying to do, because it's in custody, I want to schedule this as soon as possible. There aren't any discovery issues, so Mr. Kirker can send you over the discovery. I would like to do a PCC and set the exam as soon as possible. So I guess we're working on dates now. That's up to you, Attorney Cross, what you have available.
Okay. For an exam, the soonest I would be able to do is maybe the afternoon of January 30th. Or the afternoon of February 1st.
Let's do February 1st because okay, how about 1:30 on February 1st?
That works for me. And could we do a PCC on Friday, Judge, just to make sure that I receive all the discovery?
The 27th. Yes. Okay, so we'll do a PCC this Friday, 27th. And exam scheduled for February 1st at 1:30. Does that work for you, Mr. Kirker?
It does.
Okay. I also I ordered a DSU report for Mr. Hunter. And he's on the hold. He has a parole detainer, so he won't be released,
Okay,
just so you know.
thank you.
What else? Mr. Hunter, did you understand what just happened?
For the lawyer. He's got a new for the lawyer.
Yes, you have a new lawyer, Attorney Cross is your lawyer. Is it correct, Attorney Cross, that you will be visiting him or somehow getting in contact with him?
That's correct. I will schedule a visit with him right now.
Okay, so you can talk in more detail in private.
And Ms. Kraus, he's in the old jail, just so you know, might be a little bit easier.
Thank you.
And so we have your next court date this Friday. Make sure all the discovery is prepared and everything's ready to go, and then your exam will be on February 1st. Okay?
For Friday in person.
Friday, you can be on Zoom. And then the first, back in person, like. All right, anything else, Attorney Cross?
No, thank you, Judge.
Thank you for calling. Anything else from?
Nothing for thank you.
Okay, Mr. Hunter, I will see you on Zoom Friday, in person on the first.
Tell you what, this is a trial. I'm gonna take time off. It'll be fun.
Oh, and I did not state the time for the PTO. Okay. So I put it at 8:30. That's Bill, October Friday. That's what the jail call it. Or when they can. Here are two gifts for you. Thank you. Needed that in the afternoon.
I'm not sure. I don't think council was able to contact the defendant to review the.
What's that? What's
Is it Hopkins?
It was a KG, Mr. Riley.
We are on the record. This is People versus Brian Dion Jackson. Case number 2355024. Mr. Jackson is charged with one count of assault with a dangerous weapon belonging to assault. Today is the date set for a preliminary examination. Appearances.
Alexander Kirk on behalf of the people, P86282.
Good morning, Your Honor. Neighborhood Defender Service by Summers Fresh, number 85828. Appearing on behalf of Brian Jackson, present in the courtroom today. Mr. Jackson, please state your name for the record.
Brian Jackson.
Good morning to everybody. And are you ready to proceed?
People are your,
We are ready, Your Honor.
Okay, any preliminary matters?
I'm from the people.
None from the defense.
Okay, for the record, no one else is in the courtroom outside of staff, Mr. Jackson and his counsel and prosecutor. So we are ready to proceed whenever you're ready, Mr. President.
At this time, the people call Carl Jenkins.
Right here. Yes. Give her your name. My name is Carl. A-R-M. A-I. Territory.
Tell the truth, though. Are you faithful?
I am.
Okay.
I'll just leave it back. I'll open the door.
Put that microphone down. Make sure you speak up loudly so that everyone can hear you, okay?
Yes, ma'am. I get the best.
And whenever you are ready, Mr. President.
Could you please restate your name for the record?
My name is Carl Jenkins.
And I want to take you back to the date of December 31st, 2022. Do you remember that date?
Yes, sir, I do.
Were you at or near the location of 9950 Grace Street?
Yes, sir, I was.
Is that in the city of Detroit,
Yes, sir, it is.
county of Wayne?
In the county of Wayne.
And what brought you to that location? What brought you to that location?
I was temporarily staying with my sister and her boyfriend there.
And how many people reside in this household? How many people resided in the household at that time?
My sister, her, gosh, she has so many children. 5 children. My sister, her boyfriend, and five children.
And something happened that brings you into court today?
Yes, sir.
And what happened?
Well, I was stabbed in the back.
And what happened prior to you being stabbed in the back?
Well, prior to me being stabbed in the back, there was an argument that led up to it, which was started by
And who was this argument with?
Mr. Jackson. Brian Jackson,
And who is Mr. Brian Jackson?
my sister's boyfriend.
Is that individual in the courtroom today?
Is that him sitting there? Yes.
Could you point out that individual and identify an article of clothing they're wearing?
Here, with the white mask on his face there.
Your Honor, the record reflect identification of the defendant.
So reflect.
What was this argument over?
Over my cell phone.
And what was it?
Well,
with your cell
actually, it was because I questioned my baby niece about myself, the whereabouts of my cell phone that was left on the charger. And me and her mother went out to run some errands.
And what led to an argument based on you questioning your niece about your cell phone?
Well, when I got back to the apartment, I noticed that my cell phone, which I had left on the charger so that it would charge, it wasn't there when I returned. So I know that my niece will pick up cell phones. She's just a baby, 4 years old. So I went to the back room where the children were, and I questioned my baby niece. I said, baby, you know where Papa's cell phone is? Because usually she'll tell me if she know where it is, or she'll help me find it. And she said no, and I said okay. And I didn't question her harshly. I wasn't mean, or I wasn't yelling, or none of that. And Mr. Jackson was standing behind me in the doorway of his bedroom, which is adjacent to the children's room. And he said to me, don't you ever question my MF daughter about anything. And I said, wait a minute, I just asked about my cell phone.
And
And you
what
know she
happened?
picks up people's cell phones. So then now it's an argument between us. And then he started making threats. I'll do X, Y, and Z, I'll do this, I'll do that.
Do you recall what kind of threats he was making?
Yeah, he said, I'll shoot you. And I know he has a gun in the house.
Objection, Your Honor, speculation.
It's not speculation, it's what I know.
So let's be clear about courtroom etiquette for the rules here. So when there's an objection made by either party, you have to stop talking. The other party will respond, and I'll have a response to that. Okay? You just listen to the question, and make your answer. Okay? Okay.
Your Honor, he is testifying to his knowledge. There's the basis of knowledge, he temporarily lived in his household. And so he's just saying what he knows.
I'm going to overrule that. If Mr. Jenkins saying that he knows that, and it has a gun, that's based on, that's his testimony, whether we believe it or not is a different question, but he said he knows that that's based on his knowledge.
And at any point during this argument, did it become physical? Between you and the defendant?
When it was just verbal. When we were back by the bedroom still. And I carried it away from there because the children didn't need to be exposed to that. So I started walking toward the living room. And I told him, if you still insist on talking to me like this, then we can go outside and handle this like men. Well, at that point, he's coming, making threats still, walking toward me. And when he gets in the living room where I'm at, he lunges at me. And then that's when I started swinging at him.
And when you say he lunges at you, what do you mean by
He
this?
lunges at me and grabs me like this.
Did he grab the clothing that you were wearing?
Yes,
And this was around the neck area?
yes.
And then what happens after he grabbed you?
And when he grabbed me, that's when I started swinging. And now we're physically fighting. And
Were you and the defendants fighting each other?
now we're fighting in the living room. And I never saw the knife. It was concealed. I never seen the knife. I felt blows, what I thought were punches to my back. So we still fighting. Not me not knowing that I've been stabbed. And then a large wound on my back. I felt a blow to this area of my body. And then I felt a hot gush. And then that's when I knew I was stabbed. And
And
then
this was roughly how far into the physical altercation?
Everything happened so fast. If you can imagine that we were in the living room, tussling and fighting, I guess this was like in the middle of the physical part of the altercation.
I want to interrupt just for the record. Mr. Jenkins, you said, I saw what you did, we all saw it here, but you said, like, you pointed to one of your sides. Can you clarify which side you did?
My right side, my right back flank.
Thank you.
And I also have pictures of that injury. You can see that.
And was this the only time you were stabbed?
No, I was stabbed 5 times.
And where else were you stabbed?
In my upper back, lower back laceration. Everything was to my back. All of my injuries. 5 stab.
And when did you realize that you were stabbed?
Only the largest wound that I realized I was stabbed when I felt a hot gush. Yeah, oh my God, he stabbed
How did you know that the defendant was the one who stabbed you?
because we were the one at it. Nobody else in the world could have. Only that person that I was into the physical altercation with.
Was there anybody in the room with you at this time?
No, it was just he and I.
And was the defendant on top of you at this point?
No, I never was on the ground. I was standing up battling, and he was standing up battling as well.
And did you see the knife at any point?
I didn't see it, but I only after I had been stabbed several times. The last stab one, which is the large one to my flank, I felt a hot gush. That's when I knew I was stabbed.
And did you seek medical treatment?
Yes, sir.
Did you or someone else in the household call 911?
My sister or my niece called 911.
And what kind of injuries did you suffer?
2 punctured lungs, broken rib, nearly cut in half. I guess my right rear flank was the large muscle in my back, the latissimus dorsi was completely separate, just sliced all the way through.
And were these all the result of these stabs?
Yes, sir.
And how long did it take you to recover from these injuries?
I was in the hospital for about almost 2 weeks. And I'm still recovering now.
And what sort of injuries are you still suffering from?
I still have a broken rib. I still have the wounds on my back and shortness of breath because of both my lungs.
What further questions, Your Honor?
I just have a moment, Your Honor. Morning. Mr. Jackson. Or afternoon. not sure. So, Mr. Jenkins, you were temporary, you testified that you were temporarily staying with your sister and Mr. Jackson
Yes,
at 9950 Grace Street.
yes,
So you were a guest in their home at that time,
yes,
and you've been staying there for about 2 months?
no.
How long have you been staying there?
About three weeks.
Okay. And your sister is named Carla?
Yes,
She's your twin sister?
yes,
And she's the mother of Mr. Jackson's children.
yes,
So that evening, you came home with your sister Carla,
uh-huh,
and you were upset about the whereabouts of your cell phone.
no, I was not. We were leaving back out so that I could go skating. And I needed my phone to be able to call my sister and pick me up when the session was over. So I questioned my niece about my cell phone, at which time Mr. Jackson started to become angry and started to.
Let's slow down. So I want to focus on that conversation with Mr. Jackson's daughter, your niece. She's 4 years old, correct?
Yes,
And so you were questioning her about your cell phone, right?
yes,
And so Mr. Jackson did not want you to be speaking to his daughter, right?
that's what he said.
And that's when you and Mr. Jackson started arguing.
Yes,
Because
because he was
Mr.
talking to me in a very nasty tone
Excuse me.
and cursing me.
I understand, Mr. Jenkins, just focus on the answer, my question, that's for you.
Mhm.
So, Mr. Jackson was requesting that you not speak to his daughter.
He said, nigger, don't you ever question my daughter ever. That's what was said to me
Because Aaliyah Jackson is his daughter,
and my niece.
and you were staying at their home. And did you refuse to leave the home at any point?
No,
Mr. Jackson never requested for Carla to get you to leave
she
their
was in the
house?
restroom and never came out until after I was already staying. So she didn't know what was going on.
So, moving on, you begin to get into a verbal altercation with Mr. Jackson.
Yes, ma'am.
And you threatened Mr. Jackson at one point.
No,
You testified that you said, let's
I
go
know what I
outside.
said. I said, we can go outside if you feel like you have to keep talking to me that way.
Mr.
That's
Jenkins,
not a.
Mr. Jenkins,
Yes, ma'am.
allow counsel to ask the question, especially because it's difficult for the court to take down, so you have an accurate record of everything that's being said. The only one person.
Yes,
Okay,
ma'am.
just keep that in mind. I understand how you feel. Please let her answer the question, ask the questions. Okay.
So, just to say, you testified, you said, let's go outside and handle this like men.
That's what I said.
And that's when you and Mr. Jackson started to physically fight.
That's when he lunged at me and grabbed me around my collar, and then that's when I started swinging
And
at
so
him.
you punched him in the face, correct?
Right,
So you hit him in the face,
that's right.
and then you proceeded to mutually fight each other, correct?
Absolutely,
You were both standing.
absolutely.
And how tall are you, Mr.
I'm
Jenkins?
6'4".
How tall is?
I
Mr.
don't
Jenkins?
know,
Are you taller than him?
of course,
So you're bigger than him.
I guess.
Okay, so you're both
Stature
standing.
wise.
So you're both standing and you were both physically fighting.
Mhm.
Did you choke Mr. Jackson at one point?
During the fight, yes,
Okay, and so you choked him,
yes,
and so at this point, when you start feeling blows to your back, right?
I started feeling the blows to my back. immediately after he lunged at me and I started swinging. So when I started swinging, that's when I started feeling blows to my neck.
So after you started swinging, that's when you felt the blows to your back.
Yes,
Once again, you never saw a knife.
I didn't see the knife.
And you also grabbed the top and hit Mr.
That's
Jackson
right.
in the back.
That's
And are you,
after I was stabbed by Mr. Jackson.
and are you aware that the blows to the head caused Mr. Jackson to receive lacerations?
I'm sure he received some injury. I was fighting for my life. I was stabbed.
And once the fight stopped, your sister called an ambulance, right?
Mhm.
Mr. Jackson stayed on the scene, correct?
Yes.
He assisted in putting bandages on the wound.
No, this is what happened.
You don't mean, if it's
Okay,
a yes
well,
or no
are you
question.
gonna ask me the question and let me answer?
It
Or
was a yes or
not?
no- it was a yes or no question.
No, it's not a yes or no. Do you wanna know what
Yes,
happened
it
or
is.
not?
Mr. Jenkins. She was a yes or no question.
Okay, can you restate the question?
Did Mr. Jackson assist in putting bandages on your back?
No, he never put a bandage on my back at all.
Carla did.
My
And Mr.
sister put pressure on my
And
back.
Mr. Jackson was.
And Mr. Jackson came over after. When I had told him, if I die, do you know what's gonna happen? You're gonna go to jail for murder, and then you're not gonna see your children.
Mr. Jenkins.
And then he started putting pressure on the wound once my sister lifted up my shirt and they saw how bad it was. Now he's afraid, so he started putting pressure. That's what happened.
And so once again, he stayed on the scene,
Yes,
correct?
he did stay on the scene.
Okay.
And he
And,
openly admitted that that's what happened when the paramedics questioned him about. They
And what-
asked me who stabbed me, I said Brian Jackson. And then they asked him, sir, were you involved? Did you do this? He said, yes, I did.
that's enough, sorry, Mr. Jenkins. One moment. Mr. Jenkins, do you have any prior convictions that relate to either theft or
I've
dishonesty?
never been convicted of anything ever.
Okay, thank you. And, once again, actually, no further questions. Thank you.
Thank you.
Just wanted to ask, how did you feel when you were stabbed?
How did I feel?
Yes.
You mean mentally or physically?
Oh,
Well, I didn't know I was stabbed. At first, I thought I was just being punched in the back because it's a fight. I thought I was being punched in the back until I felt the hot gush. And then I knew that I was stabbed. And then what went through my head was, okay, you're gonna have to fight for your life now and get this weapon away from him. Because if he continues to stab at you, you're gonna die. So of course I feared for my life. And I fought like hell for my life. And that's how Mr. Jackson received the injuries that he received. And at one point, I was able to take the knife away from him almost, which is how his hand got sliced, because I had hold of the knife, so did he. He had the blade, I had the hilt of the knife, and it was digging into the palm of his hand. And that's how he received the injuries that he received.
so you're saying at some point you did have a hold of the knife?
I had a hold of the knife to keep him from stabbing me further. So he's holding it, and I'm holding it to try to get it away from him. And that's how his hand got sliced, the way that you got sliced.
And could you describe what that knife looked like?
Hunting knife about maybe this long.
Could you state the size for the record?
Maybe 8 inches, maybe 6 inches. I don't know.
Somewhere between 6 to 8 inches.
Yeah, from the hilt of the knife.
No further questions.
So earlier you testified that you were not able to see the knife.
When I was being stabbed, I didn't see the knife. I only saw the knife after I was able to repel him when I struck him in the head with the pot. Then he fell back. And then that's when I rushed toward him to get control of the knife so that he wouldn't come attacking me again.
And when you rushed towards Mr. Jackson, where was he?
Still in the, he,
Was he on the ground?
no, he was standing.
Okay.
And he was by the door frame of the kitchen. And I had reached into the sink and grabbed the pot and struck him on the head. And then I rushed to grab the weapon to make sure he could further lift harm on me because he had already stabbed.
Okay, no further questions.
Nothing for the people around.
Mr. Dickens? You weren't done testifying? Officer, come up and help.
Maybe just-
We'll have officer come over to this
door.
Oh, that's good. None from the people around.
None from the front, sir.
At this time, the people would move to bind over on all counts. That would be count 1, assault with a dangerous weapon. As we heard from the witness, there was what first started as a verbal altercation between himself and the defendant, who was his sister's boyfriend, over the location of him questioning his niece regarding the location of the cell phone. This then turns physical. What they, as the witness stated, the defendant lunged at him, grabbing him by his upper collar. Shortly into this altercation, he felt what he first described like punches, but then he felt the hot gushing feeling from his back, and that's when he realized he was stabbed. He also expressed at this point that he feared for his life and was fighting to protect his life at this point. And then he described that he stabbed 5 times with a hunting knife that at some point he was able to see. And he said it was a hunting knife that being 6 to 8 inches. He testified to he saw medical treatments, suffered some severe injuries, continues to suffer from these injuries. And based on the testimony, people believe that they have met their burden of probable cause.
Your Honor, the defense would object to the bind over at this point. The district court must consider all admissible evidence during preliminary examination, and including affirmative defenses under Colby Anderson. And I believe that Mr. Jenkins' own testimony today shows that this was a situation in which Mr. Jackson was defending himself and his home. And his testimony shows that before there was any use of the knife, Mr. Jenkins punched Mr. Jackson in the face told him that they should fight outside. That's a threat. And when someone is in their own home, that right to defend oneself is even more potent. Under People v. Riddle, the Supreme Court of Michigan case, when one is attacked in his dwelling, they are never required to retreat, or it is otherwise necessary to exercise deadly force in self-defense. When a person is in his castle, there is no safer place to retreat. And the court states in this that this is true even where one is a voluntary participant in mutual conduct. And I think Mr. Jenkins' testimony shows that this was mutual here. That Mr. Jenkins really admitted that he was throwing punches, that he choked Mr. Jackson at one point. He hit him with a pot over the head. This was mutual conduct here that resulted very unfortunately in Mr. Jenkins being injured. However, Mr. Jackson's right to defend himself still exists, especially when he is in his home, when his 4-year-old daughter is in the room, and when he's in a fight with someone who's much taller than he is. And I understand that we're at the probable cause stage here, that normally in a case like this, that there might be questions of fact involved. But because this was in Mr. Jackson's dwelling, that self-defense, that affirmative defense is clearly present when a guest in their home was involved in a physical altercation that escalated to the point where Mr. Jackson had a reasonable belief that he was in fear of his life. And therefore, we object to the waiver and ask to dismiss this.
Your Honor, well, the witness was temporarily staying at this home. It was a temporary home for a certain amount of time, so it is also his home. There's also the fact that, as he testifies to, the defendants did lunge at him first, and shortly after lunging out, when he felt stabbed. Even if the defendant felt like he was threatened in some way, to have a defense of self-defense, he needs to be present with deadly force. In this case, there was no indication of threat of deadly force prior to knife use. There were maybe a handful of punches we gathered from the testimony prior to this, but beyond that, there was no indication that this fight should have been escalated to that point. Knife is a very dangerous weapon, especially a hunting knife like this. The witness suffered 5 stab wounds, fearing for his own life. And we were asked to find over this case, we believe there's probable cause. And if anything, defense of self-defense would be a question of fact.
And I do agree with prosecutor's office in terms on that issue, counsel on self-defense would be a question of fact for the trial side. For the record, we heard testimony today from Mr. Carl Jenkins that he was temporarily staying with his sister and his sister's boyfriend was the defendant, Mr. Brian Jackson. And he testified that he was there for about 3 weeks. And I'm sorry, Mr. Jackson, did you speak while I was talking on the record right now? And then Mr. Jenkins also testified that there was an argument about where his cell phone was moved and that he approached his baby niece about it. And Mr. Jackson, Mr. Jackson's case, had issue with that. They began with a verbal altercation, it turned to a physical. And Mr. Jenkins testified that there were threats made and then lunch at different and witness, Mr. Jenkins, in the living room, and that the defendant grabbed his clothing around his neck area. The plaintiff witness began swinging, and they physically fought, and that is when Mr. Jenkins began to feel, we thought were fists at first, but realized eventually that there were stab wounds after he felt on his right side, a hot gush. And after going to the hospital and receiving treatment, he realized he was stabbed 5 times. He received 2 punctured lungs, broken ribs, large muscles, right flank or large muscles completely sliced, in the hospital for 2 weeks, still recovering. And then he still has a broken rib, shortness of breath. He also stated that he fought like hell, and then realized it was a hunting knife in which he was stabbed with. There was also no one else in the room when altercation took place, physical fighting. I believe people have met their burden of proof here to fight over to third circuit on one charge here of felonious assault. With that, Mr. Jackson, you will be gone over to third circuit for an arraignment on information on February 6th. It will be at 9:05 a.m. Timer five.
Okay, sir, you can step outside for your turn.
On the record, this is People versus Maurice Estelle, case 2260103. Mr. Estelle is charged with 1 count of weapons carrying concealed to be set for preliminary examination appearances.
Alexander Kirker on behalf of the people, P86282.
And good afternoon, Your Honor. Good afternoon, Madam Clerk. Jonathan Roberts, P86428, on behalf of Mr. Maurice Estelle. Mr. Estelle, could you please state your name for the court?
Maurice Estelle.
Good afternoon, everybody. And are both parties ready to proceed?
People are, Your Honor.
Yes, Your Honor.
Okay. Any preliminary matters?
None from the people, Your Honor.
Just ask that sequestration be enforced. I believe there's only one witness, so that should not be a problem.
Okay, and for the record, there's no one else in the courtroom but lawyer, staff. I will make sure it stays that way.
Thank you, Your Honor.
Okay, okay, you can bring in your first witness.
Your Honor, at this time, the people call Officer Deshaun Perry.
Please swear to tell the truth, the whole truth, and nothing but the truth. Okay. You go with me? Okay. Whenever you're ready.
Morning. Could you please restate, or good afternoon. Could you please restate your name for the record?
Deshaun Perry.
And are you currently employed?
I am.
Where are you currently employed?
Detroit Police Department,
And in what capacity are you employed?
police officer,
How long have you been employed as a police officer?
for 3 years.
And were you employed as a police officer on October 13th, 2022?
Yes,
Did you in fact work on that date?
yes.
Were you by yourself or with a partner?
I'm the 2 partners,
And what are your partners' names?
Officer Patton and Officer Biggs.
And did your duties as a police officer on that day take you to an area at or near West Nichols Road,
Yes,
then in the city of Detroit,
yes,
County of Wayne?
yes.
And what brought you to that area?
Routine patrol.
Did anything happen while you were on this routine patrol?
Yes,
What happened?
I was driving eastbound on West Nichols from Winston when I observed a male walk in the same direction.
In the same direction?
Yes, I was driving eastbound on West Nichols, and the male was walking in the same direction.
Oh, you said veil, I had a hard time hearing. You
Sorry.
said with veil?
I said, and I observed the male walking in the same direction.
Okay, thank you.
And do you see anybody that you came into contact with in the courtroom today?
Yes,
Did you point out that individual and identify him with what clothing that they're wearing?
yes, he said behind the defense counsel wearing a blue jacket.
Your Honor, let the record reflect the identification of the defendant.
No reflection.
And was this the individual you saw walking?
Yes,
And what did you observe?
as I was driving, I looked to my left and observed the male on the north side of 6 Mile. North side of 6 Mile, and he was walking, he observed a scout car and bladed the left side of his body away from my scout car.
And when you say bladed, what do you mean?
He attempted to hide the left side of his body.
Objection, Your Honor. Speculation as to attempting to hide.
He's testifying to what he observed. What his experience he observed.
Overruling because Officer Perry testified to what he believes observed.
And why was this blading motion significant?
Usually, in my experience, is consistent with someone trying to conceal something from me.
And what did you do after you observed this motion?
I looked back at the male and I observed him perform a retention check by touching the left side of his waistband.
And when you say a retention check, what do you
He subconsciously touched the.
Objection, Your Honor, to speculation as to someone subconsciously touching a portion.
For response? Yeah.
Acknowledge.
Okay, it's the same, because he doesn't know if it was subconsciously or not, officer period.
Yeah. So I'll ask the same question again. What do you mean by retention check? Answer with your observation.
He touched the left side of his waistband after observing my presence.
And were you in a scout car?
Yes,
And was it a fully marked or semi-marked scout?
similar mark.
And can you describe what that scout car looked like?
It's a black scout car with the Detroit police on the side of it.
Did it have sirens on the top?
Yes.
And what did you do after you saw this retention check?
I asked my brother to my observation. I turned the scout car around and we engaged the male.
And what happens when you approach the defendants?
I heard my partner, Officer Patton, ask, was the male CPL holder?
Did the defendant provide a CPL?
Did not.
And what happened after?
We exited the scout car and approached the male. At that time, he immediately placed both his hands in the air. His jacket lifted, revealing a firearm being concealed on the left side of his waist.
Can you describe the firearm?
It was a black and silver Smith & Wesson.
And what were you able to see when the defendant lifted his arm?
The firearm being concealed, I seen the barrel and the handles sticking out his pants.
And could you see this from your vantage point?
Is that one time?
Did you see this from your vantage point approaching the defendant?
Yes, once we approached him, he lifted his hands in the air, revealing the firearm.
And what did you do after seeing the firearm?
I recovered it and made it safe in the scout car.
You said it made it safe for you.
Took the magazine out and discovered that there was a live round chamber.
And was a mean search run to determine if the defendant had a valid CPL?
Yes,
Mr. Parker, the principal, he said,
Was a lien search run to determine if the defendant had a valid CPL?
yes.
What were the results?
Objection, Your Honor, to lack of foundation. I'd ask that if Parker first established that it was Officer Perry who in fact ran the lien search, otherwise it would be hearsay.
Acknowledged.
yes, I will say, I will determine whether or not officer period.
Did you run the lien search yourself?
I did not.
Did you at any point see the lien search as a result?
I watched him as my partner ran this, the defendant for CPL.
And did you see the results of the lien search?
Yes, they were negative.
And by negative, you
The defendant not have a CPL.
and was the weapon placed into evidence?
Yes,
Do you recall the evidence tag?
yes, I believe it was 684-444, -1.
No further questions.
Yes, Your Honor. Good afternoon, Officer Perry. How are you doing?
Good, how are you?
Doing well, thank you. So you made a case report for this incident, correct?
Yes,
And you've written case reports before.
correct.
You've been trained on how to write case reports.
Okay. Sure.
Is that yes? Have you been trained or received guidance on how to write those case reports?
Yes,
So you're aware that police reports are relied on in criminal cases,
okay. Yes,
and you made sure to include all relevant information in the case report that you made.
yes,
And you made that case report soon after the incident.
yes,
So it was still fresh in your mind, the incident.
yes,
And you had a chance to review that report before coming to court today.
yes.
And would you change anything in that report that you made?
I don't believe so.
Do you think anything is missing in that report that you made? So I wanted to talk about what you had referenced on direct date. As you said, you're doing a routine patrol. You say that you started off driving eastbound on West McNichols. But Officer Perry, isn't it true that you first observed Mr. Estelle as you were coming onto West McNichols?
I remember being in the gas station parking lot directly across the street, and I remember driving eastbound on West Nichols.
Specifically, Officer Perry, you turned right onto West McNichols, and that's when you observed Mr. Estelle. Is that correct?
I do remember driving east on West Nichols, and then observing.
You are aware that there is scout car video footage for this incident?
I would believe so, it's my dash cam.
And you were the one driving, correct?
Correct.
And you'd be familiar with that dash cam footage if I showed it to you? Permission, Your Honor, to approach opposing counsel and Officer Perry in turn with what will be marked defense 1 for identification purposes. Permission to approach, Your Honor.
Sure, yeah. Or, you know, different options. Whichever way works.
Thank you, Your Honor. So, Officer Perry, I will show you what video. I'm just going to play a few seconds and just let me know if you recognize it. Do you recognize this video, Officer Perry?
Yes.
That's good. So I'll ask again, so is it true that you turned right onto West McNichols and that's the first time you saw Mr. Estelle?
Yeah, as I was going eastbound, observing.
Thank you. And you had mentioned, Officer Perry, that you were in a semi-marked car, and that's different from a fully marked car, correct?
The color is different, yes.
So specifically, what would it be, a black car?
Yes, the fully marked car is white and ours is semi-marked is black.
And it was nighttime, correct?
It was nighttime.
And a semi-marked car is in its name almost, right? It's less recognizable as a police car than a fully marked car.
I would say so, yes.
And as you mentioned, the labels saying it's a police car are on the sides of the car.
Yes.
So if you're approaching from the front, someone wouldn't necessarily see a police label if they're just looking at the front of the car.
Not the label, they would.
Now, right when you turned onto West McNichols, as you said, you turned right. You then did a U-turn.
Yes.
And that was so that you could stop Mr. Estelle, correct?
Just to engage him, yes.
Now, when you first see Mr. Estelle, as you said, he's just walking, correct?
Correct.
Specifically, he's walking on the sidewalk.
Yes, you know something.
And he's walking, as you said,
yes.
When the scout car turns onto West McNichols, does Mr. Estelle run away?
No.
Does he turn around?
No, just outside of the blade of his body, no, he doesn't move.
So he doesn't change his direction that he's walking?
No.
And you mentioned him blading, and what that movement looks like. To be clear, Officer Perry, isn't Mr. Estelle walking east and then your car is going east?
Yes.
So if someone is walking east from your perspective and you're both going the same way, isn't it always going to be true, that the left side of their body isn't gonna be facing you?
It wasn't, that's true, it wasn't facing me, but it's almost like it was a slight movement, but it definitely turned left side away.
But his left side was already away from you at that point, right?
For the most part, yes.
Okay. Now, you see Mr. Estelle, and then you tell your partners, correct?
Yes,
Did they mention to you before you told them anything?
I don't believe so, no.
And at that point, you don't see a firearm.
No,
At that point, you don't see like an L-shaped bulge or anything.
not at that time.
You don't see Mr. Estelle in the process of committing any crime, to the best of your knowledge.
No.
And at that point, do you know who Mr. Estelle is? Have you ever seen him before?
Not that I know of.
So, would you agree that you wouldn't know whether or not he has a criminal background?
No.
And at that point, you don't know whether or not he has a CPL?
Correct.
So after you turn onto West McNichols and you make that U-turn, all three officers get out of the car, right?
Yes.
And you're in full uniform.
Yes.
And what does full uniform mean?
It's somewhat similar to what I'm wearing now, except it's a vest that has Detroit police on the front and the back.
And are you armed?
Yes.
And the three of you shine your flashlights in Mr. Estelle's direction, correct?
Yes, no.
Just for the record, you said what you have on. Can you describe what you have on?
Yes, I had like I said, the black vest that said Detroit police on the front and the back, green pants, boots.
Thank you. And as you mentioned, right when you approach Mr. Estelle, the three of you are in front of Mr. Estelle, right?
Yes.
So he can't really keep going in his direction without running into you.
Yes, we was engaged at the time.
And at that point, Mr. Estelle puts his hands up.
Yes.
And then you reach for the gun in his pants, correct?
Correct.
And you take the gun.
Yes.
And after you take the gun, that's when Mr. Estelle tells you that he doesn't have CPR.
I believe my partner officer, I heard my partner officer kind of engaged the mill, asking if he was a CPL holder, and I don't remember hearing the response. He heard my partner officer kind of ask him, and he did not respond.
So at that point, he doesn't say he doesn't have CPL, you're saying he has no response.
He did not respond. I don't remember him responding.
Okay, so he didn't make any representation as to whether or not he has CPL.
I don't believe so.
Okay. That's everything. Thank you, Officer Perry.
Yes.
Counsel, are you admitting video?
No.
At what point did you determine that the defendant was not a CPL holder?
After I recovered the firearm.
And when you recovered the firearm, have the results come back that he was a valid CPL holder? Would you have returned the firearm?
Say that one more time, sir.
Would you have returned the firearm if the results had come back that he was?
Yes, if he would have said that he was a CPL holder, I would have took the firearm off.
So you temporarily recovered it?
Yes.
Further investigation. No further questions?
And no recross, Your Honor. Thank you.
Okay. Officer Perry, you all set? Any other witnesses?
None from the people, Your Honor.
None from defense, Your Honor.
Okay, Officer Perry, when you're ready.
Your Honor, at this time, the people would move to find over on all counts, that would be count one, carrying concealed. As we heard from the witness, while on routine patrol, he observed the defendants in the waiting away from him, which in his experience is consistent with trying to hide some form of contraband. He then also testified that he observed him detention check, which again, his experience is consistent with Amsterdam. At this point, officers exited the vehicle and engaged with the defendant, who raised his hands in the air, as Officer Perry testified to. In plain view, he could see the handle of the firearm in his waistband, in the defendant's waistband. At that point, he recovered the firearm pending further investigation as to whether the defendant was a CPL holder. He heard a partner ask if he was a CPL holder, no response was given by the defendant to that question. He then observed a lead-in search being conducted, at which point it was determined that the defendant did not have a valid CPL. The weapon was placed in evidence and the defendant's state custody. People believe they met their burden in establishing probable cause in this case and would ask to find out.
Your Honor, at this time, we are moving to dismiss all charges against Mr. Estelle for a very clear reason, based on Officer Perry's testimony. Mr. Estelle was unreasonably stopped and illegally stopped. When we are looking at the timeline of events here, we have to determine when the stop occurred. It's clear, based off of Officer Perry's testimony, that the moment those three officers get out of the car in full uniform, armed, shining their flashlights in Mr. Estelle's direction, he is stopped. So we have to ask, at that point in time, do officers have articulable suspicion and reasonable suspicion that a crime is occurring? It cannot be a hunch. It can't simply be based off of officer experience in the past. They have to observe some particular evidence. And that's the problem in this case. And specifically, I believe this court, our Supreme Court, has spoken to this before, and People v. Champion. And I have a copy of that case if your Honor wants to reference it. But the stop has to be valid at its inception. You can't find something later on to confirm your hunch. The problem here for the government is that Mr. Estelle's behavior is normal. It's totally normal. He is walking, as Officer Perry admits on the stand, he is just walking on the sidewalk. Nothing is happening. But naturally, the left side of his body is not facing the officer. The moment, however, Officer Perry sees him, he says that he does not say he has a hunch, but Your Honor, if someone slightly moves their left side and perhaps Officer Perry sees Mr. Estelle touch his left side, but he can't see the left side, he testified very clearly that he did not observe a bulge, that he did not observe any object consistent with a firearm. It was just based off of his experience that when people make movements like this, they might be hiding something. That is not enough under any constitutional standard to say that I think that there's something there, so let me dig into it so I can confirm my suspicion. And importantly, Mr. Estelle does not run away, he doesn't change his direction, he makes no furtive gestures, which is often what you will hear an officer say when they get on the stand is, you know, he's trying to get away, he's trying to evade the police. Mr. Estelle, very clearly, the moment the police stopped him, put his hands up, right? There's nothing there that is suspicious, particular. And there's no firearms exception to the reasonable suspicion requirement, Your Honor. So it's not enough, as the United States Supreme Court said in the JL, it's not enough for officers just to say, well, we ended up finding the gun, and therefore, we would have found something, and our hunch was correct. We have to ask at the time of the stop, when all Officer Perry can say at that point is he sees a male walking on a sidewalk. His left side is faced away, and there is no object. The only time he sees an object is when Mr. Estelle has been stopped. Once Mr. Estelle has put his hands up and the gun in his hand is exposed. If that's the moment where reasonable suspicion exists, then that means the stop itself is invalid because it is constitutionally prohibited for officers to fare and fish in that way. It's not to say that this officer is a bad cop. It's not to say that this officer does not generally respect his duties, but if we're looking at this particular situation, the timeline is determinative, Your Honor. If you don't find the gun until later, importantly, if you don't have any experience with this person until later, because Officer Perry, this is his first time meeting Mr. Estelle. So he has no knowledge whether or not Mr. Estelle has a criminal background that would prevent him from having a gun. He doesn't know whether or not he has a CPL. It's not enough for you to stop someone and then start digging and searching. I will note just as an endpoint, APA Parker said that during redirect had mentioned that the firearm was temporarily recovered until we could figure out what was going on. That's a seizure, right? We don't call that a temporary recovery. In constitutional terms, that's a seizure. So if at that point you do not know whether or not someone has a CPL, an officer does not have the right to take things out of someone's pocket without reasonable suspicion, without a basis. On those grounds, Your Honor, we are contending that this stop was illegal, it was unconstitutional, and therefore the CCW charge should be dismissed. Thank you.
Your Honor, we would argue that there was reasonable suspicion by the time that the officers exited the vehicle. As Officer Perry testified to, he witnessed the defendant, as he described, blade his body away from him. In his experience, this is consistent with either somebody trying to hide a weapon or contraband. In addition, he then observes, on further observation of the defendant, he observed him described as a retention check, which is to grab an object on the left side of his body, or on the left side of his body. At this point, officers then exited the vehicle, and before they could ask any questions or engage with the defendant, he would raise his arms in the air. From that point, they could clearly see a firearm that he did. Defendant did not provide a CPL. Officers have to have some way of determining whether somebody is validly carrying. To open carry, you have to provide officers with the CPL upon question. I would argue that they did have reasonable suspicion to detain the firearm pending further investigation through a lien search after the defendant failed to provide CPL. Just now that the case is not over.
Court heard testimony from Officer Perry, who was partner Officer Patton and Biggs in what he described as full uniform, the green pants, black vest, boots. He was also the driver of the vehicle on routine patrol eastbound on 6 Mile, where he observed male walking, who in this case was the defendant, Mr. Maurice Estelle, walking in the same direction. And he also said that he observed the defendant blading the left side of his body, which through cross was already not visible to Officer Perry. And Officer Perry's observation, he believed to be the defendant was hiding something. He also observed the defendant do what he called a retention check, which the defendant touched the left side of his waistband. At that time, the defendant or Officer Perry turned the car around, and that is when they engaged the defendant, and the defendant placed both of his hands in the air, and that's when Officer Perry saw that, or testified that there was a barrel and handle that was showing that a gun was partially concealed, but also partially sticking out. Officer Perry then recovered the gun, and the gun was taken from the defendant until link search was done. Link search revealed that the defendant did not have a CPL. So the question here is what's happening on all these cases where there's a stop. I believe certain units do it, I'm not sure. But the question or the issue here, the defense counsel brought up is whether or not there was reasonable suspicion to even to stop the defendant. And this is a probable cause standard, and I do believe on this case, the people have barely met their verdict. The testimony from Officer Perry with the blading plus the retention check is the probable cause standard, reasonable suspicion for him to engage. And testimony after that showed that the defendant didn't put his hands up, and he was able to see that there was a gun. I think this is a very close one. I don't know how it will survive across the street, but I bring a bind it over. You know, the people met the probable cause standard, so the bond over for AOI, arraignment on the information date of February 6th at 9 o'clock.
Hello.
It's February 6th, right now.
Yes.
Hello.
Mr. Bree, have you tried to identify this iPad?
Oh, ma'am, on the iPad.
Yes.
Thank you, Your Honor. Thank you, Madam Clerk. Thank you, Madam Court Reporter.
What's your name, ma'am?
Ileana Velasquez.
I can't hear you. Hold on.
Ileana Velasquez.
Say it one more time.
Ileana Velasquez.
Okay, you should be in courtroom 332 with Judge Williams.
So would that be a different number? Because when I called the thing, this is the number they gave me.
360-332-0000.
And then, can you say the last four? I'm sorry.
Last four is 0000.
Okay, thank you.
So 360-332-0000. Got that?
I'm sorry, I'm just gonna repeat it one more time. You said 360-332-0000.
Yeah, yep.
Okay, thank you.
You're welcome. And then I'll start till 1:30, so you may have to wait a few minutes.
Okay.